So the Constitution is no longer has fixity, is no longer the established means of deciding. It no longer supplies the principles which govern and guide the Supreme Court in its decisions. It does when they want it to, but if they choose to ignore it, they simply ignore it. And so we're, again, being given decisions which is affecting not only we the people, but the states that have no root in the Constitution of the United States. He was followed, Langdell was followed by the man by the name of Roscoe Pound. Roscoe Pound came up with the theory, he built on what Langdell did, came up with the theory of sociological law. Sociological law, simply stated, means that the court keeps the law abreast or brings it up to meet specific changing, fluid needs, changing needs of the society at any given time in the period of the nation's history. And so in essence, law becomes whatever the judges think that it should be, or whatever the needs of society happen to be. The aim of such jurisprudence is to meet the changing needs then and the wants of society. Under sociological law, there are no absolutes. The law is fluid, it flows. The judges determine what direction it takes, what content it contains, what substance, what impact it may have on the nation. Pound said that the Supreme Court, and I quote him, are the engineers to mold society to the ends they think best. Now, the Declaration of Independence says that we have a government by the consent of the people. As Mark Levin says, we live in a post-constitutional America. This is no longer a government of the people, by the people, for the people. That is now gone. It's passé. It's past. And I think we have only to look at Washington, the decisions that are coming out of Washington. 70% of the American people did not want health care. We got it anyway. And so it is with many other decisions as well. Pound also was of the impression, or was also of the mind, that the state, when he says state, he means the federal government, those in power. The state is now, he said, the lawgiver. The state, he said, takes the place of Jehovah as the lawgiver. So obviously the Christian roots of this nation, supplied there by the, or rather enumerated there in the Declaration of Independence, mentioned 4 times. God is mentioned 4 times, the laws of nature and of God. And certainly the Constitution is to be interpreted by that. So the case law method then has revolutionized the legal system in America. Second, the natural law, the higher law that formed the foundation for Western law from 6 AD until about the 19th century, no longer supplies the foundation for law. And this is why we're getting, as we'll see in a moment, we're getting a range of decisions that are completely contrary to natural law, to the higher law of God, to what is moral, what is right, what is in accord with our traditions, our beliefs, our values, since the very inception and beginning of this nation. No one can examine the history of this nation, beginning with the Jamestown Charter of 1606, or whether you look at the Mayflower Compact of 1627 or 22. No one can look at those. Look at the constitutions, or the covenants rather, of those colonies, the constitutions that followed for the states, the Declaration of Independence, the Constitution. If you look at our entire history of this nation, if you look at the constitution of all of the states, they make reference to God and their dependence upon God. There's no way in the world that anyone objectively can look at the history of the United States of America and say that it's not a Christian nation. It is a Christian nation by its founding and by the order of which it's established. A man by the name of William Blackstone wrote commentaries on the law, on the Constitution. And he was a Christian, and his commentaries were well read throughout the colonies and was the foundational book for young aspiring attorneys and judges and so forth. And listen to what he said about the foundation for law. He said, upon these two, or upon two foundations, the law of nature and the law of revelation, depend all human laws. That is to say, no human laws should be suffered to contradict these. James Wilson of Pennsylvania, who was a signer of the Constitution, said, human law must rest its authority ultimately upon the authority of that law which is divine. Alexander Hamilton said, no human laws are of any validity if contrary to those dictated by God. So it must be held firmly in mind that there is an intimate connection between the Declaration of Independence, has 4 references to God. It speaks of inalienable rights, those rights that are given to us by God. The Constitution then having as one of its primary functions to protect those rights that God has given us. And our other rights, our natural rights, if you will, as part of our humanity. It was established to govern, to protect, to ensure that they stand. Listen to what John Quincy Adams, the son of John, as you know, and John Quincy was the 6th President of the United States. This is what he said about the intimate connection between the Declaration of Independence and the Constitution of the United States. The virtue which has been infused into the Constitution of the United States was no other than those principles which have been first proclaimed in the Declaration of Independence, namely the self-evident truths of the natural and inalienable rights of man and the sovereignty of the people. He said, always subordinate to the rule of right and wrong, and always responsible to the supreme ruler of the universe for the rightful exercise of that sovereign power. This was the platform on which the Constitution of the United States has been erected. What a powerful, powerful statement. Unmoored from the Constitution, rested on the higher law. The law then assumes a secular foundation. It assumes a foundation devised by men out of reason, out of worldview, out of their own personal morality. They have some other base for deciding what is right, what is wrong, what direction this nation will take, what substance shall form the law. Another factor contributing to the constitutional crisis is the abandonment of original intent. Original intent. Textualism, it's sometimes called. Judge Robert Bork, he died here a few months ago. He was, as you know, appointed by President Reagan for a seat on the Supreme Court of the United States. The liberals, the progressives, went to work on him and essentially sought to destroy him and were very successful in calling into question his legal qualifications, but said to be one of the brightest constitutional authorities around, a former law professor. Sat on the second highest federal court there in D.C., next to the Supreme Court in power and reach and so forth. He said that original intent is now passé. That is, it is out of date, it is outmoded. Yet adherence to original intent, he said, is the only way to preserve the Constitution. It is the only way to preserve the Constitution. It is the only way to preserve federalism. It is the only way to preserve the Bill of Rights. When I say federalism now, Mr. Madison in the Federalist Papers said that the Constitution has given us a compound republic. And when he said compound republic, what he meant was a federal government and the government of the states. A compound republic. That's what meant by federalism. And the federal government has only those powers that have been delegated to it by the people of the states. And those powers delegated, he said, to the federal government are of limited, they are limited and defined powers. Very limited. But he said innumerable powers were retained by the states. Mr. Hamilton said the sovereignty that the states possessed and held before the enactment of the Constitution, of the ratification, they still retained. The only sovereignty they surrendered was the sovereignty of those particular acts that they delegated to the federal government, which they once had sovereignty over, but they surrendered them to the federal government in order to have a more efficient form of government to overcome some of the weaknesses of the Articles of Confederation. Justice James Wilson said the first and governing maxim in the interpretation of a statute is to discover the meaning of those who made it. Does not an attorney, or a judge rather, if he has a will before him, if he has a contract before him, what does he look at? What does he examine? The words. The words. What do these words mean? What did the people who wrote this contract, the parties who were entering into this contract, what did they mean by the use of these words? What were their intentions when they entered into this contract? Or what was the intention of the person who wrote this will? That's what he looks, that's what he examines, and on that basis he makes his decision. James Madison said, if the sense in which the Constitution was accepted and ratified by the nation be not the guide for its expounding, there can be, he said, no security for a consistent and stable government more than a faithful exercise of its powers. Do we not see the truth of his words today? There is no faithful exercise now by the federal government of its powers. They exercise whatever powers they decide to take for themselves, by hook or by crook. They take the powers and they exercise them as they see fit. Increasingly, state sovereignty is being eroded. Increasingly, they are imposing upon the people, denying us our rights, our liberties. Increasingly, they are dictating to the states. And so we see that the order established, the governmental order established by the Constitution, has been severely weakened and continues to be dismantled. The Constitution now has become essentially a mere historical document. It has become protean, if you will. Protean means it has a lot of flexibility now by virtue of what the court has given it. It flows, if you will. It's being molded, as Mr. Jefferson said, and shaped. It has become pliable. They open up words and give them new meaning. Substantive due process, for example. Due process in Article 5 or in Amendment 5 and in Section 1 of the 14th Amendment. Due process. You cannot deny a person life, liberty, or property without due process of law. Now, anybody with a grain of common sense sees that that is a procedural, a judicial setting of due process. You cannot take from a man his life, liberty, or property without due process of law. They've opened up due process now and given it substantive meaning, which it has whatever meaning the court wants it to have. And that's how they have invaded states' rights. That's how they have given rights and liberties never to be found anywhere in the Constitution of the United States. Dean Terrence Sandbelow, I think he's of Yale Law, teacher of constitutional law. Listen to what he said. This is troubling words. Listen to what he said. The evolving content of the constitutional law. Now, notice the word evolving. You remember the words of Langdale? 1870s, Harvard Law, Charles Darwin. Law shall be evolving. You see, the seeds were planted in the 1870s, now bearing its fruit, and has been bearing its fruit in a much more pronounced way since the appointment of Earl Warren to the Supreme Court in 1953 as Chief Justice. They set in motion, he with his cohorts, his liberals, set in motion a legal revolution which we are yet in the midst of today, a revolution that is growing more deep and more costly, more consequential with each passing year. The evolving content of the constitutional law is not controlled or even significantly guided by the Constitution, understood as a historical document. The Constitution is not the base for law any longer.